As you're reading through your chapter on employment discrimination, you're going to encounter various different legal frameworks for attacking discrimination. So we're going to look at Title VII in particular, mainly to come up with a framework for understanding discrimination that can be applied and transferred to other situations. So in the middle of the 1960s, 1964, we have the Civil Rights Act, 1964, and in that act is the Title VII. Just imagine what's going on in the 1960s. We have the civil rights movement trying to end racial discrimination, and we have a sitting United States Congress, the House and the Senate, passing these laws, and we have a sitting president signing them into law. They became effective, at least legally, immediately, but we're still having some issues. So in the employment context, in the business context, we need to drill down and see precisely what we're allowed to do and what we're not allowed to do as employers. But also keep in mind that we can think about this as humans too. This is really bad. Humans could do better, but we didn't do better. And so we had to have statutory framework come alongside the constitutional framework. So if you remember from the constitutional law chapter, in the Bill of Rights and then other amendments, we don't allow the state, or the states, we don't allow the state to discriminate against people when they're exercising fundamental rights or on the basis of equal protection, treating members of a class differently, or members of different classes differently. We don't allow the state to do that. That's the constitutional framework. Well, now we've extended this discrimination or prohibition against discrimination to not just the state governments and the United States of America, but also against private employers too. So two key terms, employment discrimination and protected class. So what we mean when we say employment discrimination is the unequal treatment of employees or job applicants on the basis of some defining characteristics: race, color, national origin, religion, sex, age, disability. Those kinds of things that are protected by federal statute. So when someone is a member of a protected class, it just means they're sort of grouped together as persons, and they're protected by specific laws, and those characteristics that are germane are just the same: race, color, religion, national origin, sex, age, and disability. In particular, Title VII prohibits job discrimination against employees, applicants, and union members on the basis of these 5 characteristics. That's race, color, national origin, religion, and gender. Now, I'm saying sex instead of gender. I'm doing that on purpose because we have the United States Supreme Court case. It's the Bostock case. And it expanded the protections by the sort of the plain language of Title VII. It expanded that to things like sexual orientation, transgender persons, and things like that. So I'm going to use the word sex, but gender also is probably appropriate too. And so Bostock basically said that you are discriminating on the basis of sex when you discriminate against someone because he or she is transgender. And so I'm going to use the word sex because Bostock. All right. So the Civil Rights Act, Title VII of the Civil Rights Act, it bans any kind of discrimination at any stage of employment as well. So that's the hiring process, employee discipline procedures, someone being terminated or discharged, or even being promoted or not being promoted, and then benefits. So when does Title VII apply? Well, this is to whom it applies. Employers that have 15 or more employees, and then labor unions with 15 or more members. Also, it applies to labor unions that operate hiring halls. Also applies to employment agencies, state and local governing units or agencies, and then this is key, most federal government employment. Most federal government employment. So when Title VII does apply, any employee, including an undocumented worker, can bring an action for employment discrimination. There are 2 types of employment discrimination. One makes perfect sense. It's intentional discrimination. The other one, it makes sense, but not necessarily linguistically. It's unintentional discrimination. So normally when you use the word discriminate, you're talking about a mental process where you're intentionally discriminating. Maybe you prefer Chicago-style pizza as opposed to New York-style pizza. And so you're discriminating based on taste. You're doing that on purpose. You have a preference. Unintentional discrimination is different. And so I want you to think about it. Don't get confused about intentional versus unintentional. We're going to use some more sophisticated language. We're going to call it disparate treatment discrimination. That's intentional discrimination. And that's a form of employment discrimination that results when an employer intentionally discriminates against employees who are members of a protected class. Intent is sometimes difficult to prove. The best way to do it is if you ask someone a question on the stand or at a deposition under oath, did you intend to discriminate? And they say, yes, I did it intentionally. Imagine with me that that doesn't happen very often. So here's the prima facie case. I want you to key into that, the prima facie case, or the case on its face. A plaintiff who sues on the basis of this intentional disparate treatment discrimination must first make out this prima facie case. And what I want you to picture in your mind maybe is a metaphor of playing tennis or volleyball or pickleball. First, you have to get the ball over the net. If you don't get the ball over the net, the defendant never has to get the ball back over the net. If you are not successful in getting the ball over the net in the first place, then the defendant has nothing to do. And that's the same thing here. First, the case has to be proven up, and that is called a prima facie case. In order to establish a prima facie case of disparate treatment discrimination, a plaintiff has to show four things. Number one, the plaintiff is a member of a protected class. You either are or you're not. Two, the plaintiff applied and was qualified for the job in question. This is key. Imagine that you have a young woman and she applies to be the head of surgery at Johns Hopkins Medical Center, this hospital. And instead, a male surgeon is hired. And she complains and she says, this isn't fair. You discriminated on the basis of sex. He's a man, I'm a woman. And it turns out that she hasn't even graduated from college yet. Well, she certainly hasn't gone to medical school. She hasn't done a minimum of 5 years in a surgical residency. So the idea that she would think she was qualified is absurd. Now that's kind of a reductio ad absurdum argument. But if you're not qualified for the position, you don't have your prima facie case. Third, the plaintiff was rejected by the employer. Finally, the employer continued to seek applicants. So we have continued to seek applicants for the position or actually filled the position. And you filled the position with a person who's not a member of the protected class. That's the prima facie case. Once you have the prima facie case, you've essentially gotten the ball over the net. Then the defendant, the employer, has to come up with and articulate a legal reason for the discrimination that was alleged. If the employer did not have a legal reason, you're done. The plaintiff wins. But assume with me that employer can articulate, and this is key, articulate a legitimate reason for the action. If the employer can articulate a legitimate reason, then the burden shifts back. Picture with me the ball going back over to the plaintiff. And then finally, the plaintiff is done unless the plaintiff can somehow show that the employer's reason is really pretextual. It's not the real reason. It's not the true reason. Really, the employer's decision was actually motivated by the discriminatory intent. So it's this picture with me, this metaphor of hitting a ball over the net. That's the prima facie case. The defendant has the opportunity to hit the ball back over the net. That's by articulating a legitimate legal reason. And then the plaintiff has this additional burden then to prove that, well, that was pretextual. You say that, you articulated it, but it's not really why you did it. That is intentional discrimination. Next, we have unintentional discrimination, and this is the disparate impact discrimination. So not disparate treatment, but disparate impact. And it's a little bit different here. Courts have established procedures, nonetheless, to be able to prove these cases up. But this is the kind of discrimination that results not from anything that is overt, but from practices, from tests or procedures that, although they're not going to be discriminatory on their face, or it would be disparate treatment, they're going to have a discriminatory impact. So for this unintentional discrimination, there are essentially two ways of proving this up in court. That is by showing the employer's practices, procedures, or tests are somehow unintentionally having an effective discriminatory impact. That is, a disparate impact discrimination exists. The first is by comparing the actual workforce of a particular employer, comparing that workforce to the pool of qualified applicants in the local labor market. And this is what a plaintiff has to show, that as a result of some sort of procedure, educational requirement, job requirement, or hiring procedure, that the percentage of non-whites, women, or members of some other protected class in the employer's workforce doesn't reflect that same percentage that's in the group of the qualified applicant pool. So assume with me that there is a group of qualified applicants in this pool in the local labor market, and it is 50-50 male and female. There are 50% of them are men and 50% of them are women. They're all qualified. And let's also assume that a local employer hires 100 engineers, and all of the engineers are men, even though the applicant pool is 50-50 men and women. If you could show that it was a result of some sort of job requirement or a hiring procedure, you would have a case not for intentional discrimination, that would be a different way of proving it up, but unintentional discrimination. And the second is like the first in some ways, and it's by comparing not the pool of applicants to the workforce, but the selection rates of members and non-members of a protected class. And EEOC has some guidelines for that. So as you're reading through this employment discrimination chapter, keep in mind, although Title VII is only one piece of legislation that protects and bans discrimination, there are others. It's important to make sure you understand how the Title VII works from start to finish. You understand how it works, where the burdens are, and that you can take that paradigm and you can apply it in other situations where maybe it's age discrimination. Well, Title VII doesn't protect against age discrimination. There are other pieces of legislation that do. So keep that in mind, and good luck with this particular chapter.